that dispo, you can just email it to me and we'll get Judge Cooney to sign it.
Okay.
All right, good afternoon. This is People versus Everett Ayers, and that is file number 2115515SM1. And let's see, we have Ms. Schultz here on behalf of the people and Ms. Chartier on behalf of the defendant. And Mr. Ayers, are you able to hear okay?
I am, sir. Thank you.
Okay, great. All right, this is the date set for a plea in this case. And so, Ms. Schultz, has there been any plea offer?
Your Honor, there has. The offer in this case is that the defendant would plead guilty to the domestic violence. In exchange for that plea, the people would recommend a delay under the domestic violence provision. It was also our understanding that this plea would not have to be reported to the Michigan Bar Association, in that it is held in abeyance and there technically would be no conviction. If that was not the case, then the defendant would have the right to withdraw his plea without prosecutor objection.
Okay, so I didn't realize Mr. Ayers is an attorney then.
Yes.
Obviously. And I was trying to recall the reason for Judge Burmeister recusing himself, but I guess that's it. So he probably knows Mr. Ayers from court. Well, I guess, Ms. Schultz, have you researched this? Is this
I have,
something that should be withheld from the Bar Association, or there's?
Well, first of all, I contacted the Prosecutors Association of Michigan, and I do have an email from the president of that association that indicated that is not something that I would be required to report up and until, if it happened, then there was a violation of the delay period. And then the conviction would be entered. I would have to report it at that point. But I would not have to report it unless there was a violation. I also had contact with a Miss Cindy Bullington from the from the State Bar. She's works for the Attorney Grievance Commission. And she told me if the plea, if there's no conviction entered and the plea is held in abeyance, which is what the domestic violence statute requires, then there's no need to report unless the plea required an element of theft or dishonesty, then that would have to be, which domestic violence doesn't, then that would have to be reported even if the conviction wasn't entered, was the information that I got.
All right. Well, I'm assuming the same is true for the court's reporting duties then. And Ms. Chartier, have you researched this, and is that your understanding as well?
So we've researched it as well as and Mr. Nyamfukuza has, and there does seem to be some sort of vagueness to it. But he spoke to Ms. Bullington, and she indicated that the only way the reporting could be avoided is if the court held the plea in abeyance for whatever reason, and then Mr. Ayers wouldn't have to report it, but and neither would we. But it's our understanding, and Mr. Ayers, you can confirm that you're not interested in accepting the offer, correct?
That's correct, ma'am.
Oh, I guess I didn't understand that. So Mr. Ayers is not accepting any plea at this time?
Correct.
Okay. All right. Well, that makes it simple and less for me to think about anyway. So, all right. So, and I guess I just want to confirm that with you, Mr. Ayers. Obviously, a deferred sentence is typically a pretty good deal. You could walk away without any conviction in this case if you follow all the terms and conditions of probation. And it's possible that this doesn't even get reported to the Bar Association. And as an attorney, I'm sure you realize that if you're convicted, there will be a conviction, and it obviously would need to be reported to the Bar Association. But I'm sure you've thought about this a lot. You've discussed it with your attorney, and you're rejecting the plea offer at this time, correct?
Yes, Your Honor.
Okay. All right. Well, I guess the next step would be to set this for trial. And typically what we do in this county anyway, or this district, is we set cases for a final conference to give the parties, I guess, one more chance to try to resolve the case before going to trial. And that's been true since the pandemic hit, because we've had a lot of cases stacking up because SCAO is not allowing us to hold jury trials currently. The hope is that we will be back to doing jury trials in mid-July, maybe picking juries for those cases at the beginning of July, just to give you some idea. And so I think what we'll do then, well, let me ask the attorneys here, Ms. Schultz and Ms. Chartier, do you think there's any reason to hold a final conference, or do you think the parties are pretty settled on going to trial, and maybe we should just go directly to the jury selection?
Oh, go ahead, Ms. Schultz.
I never see a harm in a final conference.
Okay, Ms. Chartier?
I agree with Ms. Schultz. There is an issue of outstanding discovery. The court had recently signed an order for some witness interviews, so we're waiting on those from Ms. Schultz. So I think a final pretrial is good, just to make sure that all the discovery has been obtained and there are no outstanding issues. The other issue, as the court probably knows, is now that other counties are opening up for trials, we currently have 2 scheduled for the end of July. And so I think a final pretrial is good, just because then if there's any sort of scheduling conflicts, we might be able to address those.
Okay, how much time do you think it's going to take to get those tapes to the defense, Ms. Schultz?
I think, let's see, we were waiting for, we had it on the 24th, and it looks like they were already mailed out.
Great.
Yes, we got a protection order.
Okay.
It was signed on the 24th, and it looks like they were mailed. There's a proof of service in the file. So if you don't get it within, a few days, just give us a call and we'll resend.
Sure, thank you.
All right. Well, then let's set the final conference out, since we're not in any rush, because our jury picks aren't going to start until probably July. How about 30 days out? And then we do have 150 cases backlogged right now because of the pandemic that are set for jury picks. And so it's likely that this pick is going to be out further. We're kind of prioritizing cases according to the charge and that sort of thing. So, Ms. Odom, you want to pick a date that works for both Ms. Schultz and Ms. Chartier?
Yeah, and you just want just a regular final conference that we
Yes.
hold here.
And I do hold those on the record. I think there's value in having all the parties present, the attorneys, and Mr. Ayers. I would want him to be here as well. So if there is another offer or anything else we need to discuss, that he's here and we can get that resolved. So
What about Wednesday, June 30th?
Wednesday, June 30th?
Mm-hmm.
That works for me. Mr. Ayers, does that work for you?
Yeah, I'll make it work.
Great, thank you.
Okay. You want to hold it in the morning? You would just zoom into our regular morning docket with the same Zoom information that you already have, and we could do that at like 10 o'clock. Would that work?
Perfect.
Okay,
Okay.
Ms. Schultz, is that going to work for you as well?
Well,
All right, great. Okay, so you'll get a notice in the mail of the next hearing then. And is there anything else we need to take up today?
No, thank you, Your Honor.
All right. I will do a little more research here and determine whether or not, just in case the issue comes up again in a plea situation, whether the court would feel compelled to notify the bar of a conviction in a situation where no conviction has been taken, because with a deferred sentence, there is no conviction in my view unless and until there's a reason to enter that, which would be a probation violation justifying revocation of the probation. So okay, so that's it for today. We're all set, and feel free to sign out at this time. Thank you all.
Thank you, Your Honor.
Thanks. Talk to you later, Mary. Have a good
Thank
weekend.
you. You too.